I am David Sanford of Sanford Heisler Sharp McKnight, chairman of the firm, and I'm delighted to be here today with Michael Palmer. Michael is co-chair of our Wage and Hour National Practice. He also is co-managing partner of our New York office. Welcome to this interview.
Thank you very much, David.
Michael, you've been with the firm how long now?
Oh, I've been with the firm for over 12 years.
Hard to believe, right?
It is a little bit hard to believe at this point.
Wow. After UT Austin, you went to law school.
I did.
And you went where?
Went to NYU.
NYU. So you did wind up at NYU, just not with a joint degree.
Right.
And what were some formative experiences there that led you to be committed to or reinforce your commitment to civil rights and public interest law?
So I'll start off by saying that even before law school, I was really fascinated by individual rights and the need to protect those rights. And, this actually went back to high school when I was studying, the Bill of Rights, and continued on in law in undergrad and then law school. In law school, I worked for the ACLU a couple of summers, dealing with prisoner rights. Was a major thing that I dealt with. And then in my third year, I took a course on employment discrimination, and I really connected with it. Discrimination comes in so many forms. There's, very overt discrimination, some of the worst racist comments you sometimes hear about in our job. Then there's, less overt kind of implicit bias, or there's sexual harassment. There's all these different ways in which employment discrimination manifests itself. And I found it really compelling how the law confronts these issues, how it attempts to remedy them and eliminate discrimination, or at least, try to rectify it for individuals on an individual by individual basis. And so, that really connected with me. And after law school, I got a job at a small plaintiff's employment firm, and started working on employment discrimination cases. But I started working on other stuff too. Other employment matters, such as wage and hour retaliation cases, that kind of thing. And I really enjoyed the work. I enjoyed the variety of work that I was handling, and it was really interesting, just simply the range of matters we'd handle. But at the same time, it always came back to the idea that you were helping to achieve justice for your clients. And, with that, it meant that I really got something out of the work every day, no matter how difficult the work was, no matter, how challenging it was, knowing that I was doing everything I could for my clients to achieve justice. I really feel like I've always felt like this is the work that I'm meant to do.
So how did it come about that, given that passion and your obvious intelligence and commitment to this area, that you wound up coming to us and that we became the beneficiaries of your vision and your commitment?
Sure. So, David, we had an opportunity to work together back when I was at that small law firm, because we handled, as I said, some wage and hour cases, and as does Sanford Heisler, and we were basically doing some overlapping work against pharmaceutical companies, where these pharmaceutical reps were working very long hours, and we argued that they were entitled to overtime compensation. And through working on those cases, I got to know you and some of your partners, and always had great respect for everything that you've done over here. And when I was starting to think about my next move, I connected with you about the possibility of working together. And that is what happened ultimately, that you offered me an opportunity to join, and I jumped at it.
Well, we're delighted that you did. And you've been here, as we talked about initially, for 12 years. What are some highlights that you take away in the last 12 years? You've worked on so many matters. You've done probably, certainly well over 100 pre-suit matters leading to confidential settlements. You've done trials. You did a major trial against Oracle, against Schlumberger.
So the Oracle case is really, it's interesting in some respects because it relates back to what I was talking about with this other matter, learning a new area, because it's a wage and hour case, but it is a case involving the California Private Attorney General's Act. And I was not super familiar with PAGA, as that statute is called. It's a really interesting statute that allows employees to bring claims for violations of law, violations of the labor law in California, and obtain penalties. These claims would typically, prior to PAGA, have only been able to be brought by, say, California agencies or, the state of California.
And they can obtain penalties, just to be clear, meaning money.
Meaning money, yes. So in the past, it would have to be the state going after the companies. But under PAGA, the employees could go after the companies for these violations. And now this was a case that started in 2015. I joined it not right at the beginning, but a little thereafter, and started to become a lead attorney on it. And it involved a variety of different things concerning their commission plans not being compliant with the law, and people not being timely paid all of their commissions. And this was brought on behalf of thousands of sales employees for Oracle. We had 2 phases of trial just on liability alone. And each phase went on for weeks. And ultimately, the court ruled that there were violations of the labor law here in a variety of different ways where, say, for example, commission plans weren't properly signed and commission plans weren't issued in a timely fashion, and then people were not paid commissions in a timely fashion, and there was commissions withheld. These are some of the violations that the court found. We were ultimately, it looked like we were going to be going to a third phase of trial, this time on the extent of the penalties. But we're ultimately able to reach a significant settlement, which for $15.5 million, which was an incredible result for all the employees, for the plaintiffs, for the state of California.
I remember a case, seems like a long time ago, probably was 8 years or so ago. You were involved in a case against an entity in Alaska, and you would hop on planes. I was working a lot out of the New York office, and I remember saying goodbye to you or welcoming you back from Alaska. You would hop on planes and travel from New York to Alaska, time and again, involved in that litigation. Talk a little bit about what that was like.
Sure. So that was another really interesting case. So it actually was one that started before I joined the firm, and I came on and began to work on it shortly thereafter. It was a misclassification case, and by that what I mean is that the plaintiff and the class alleged that workers were misclassified as exempt from overtime. In this case, they were sales employees who sold service for a telecom company. And the company alleged these people were exempt both under what is called the administrative exemption and under the outside sales exemption. And this case, it started back in 2012 and continued on. And we were successful throughout the entire course of the case, and were able to obtain class certification, both collective certification of the FLSA claims, the federal overtime claims, class certification of the state law for the state overtime claims, and throughout all this, yes, I would be going back to Alaska. Now, this was, of course, in large part pre-COVID and pre-remote depositions. So, there was a lot of travel for depositions, both taking and defending depositions. You
would have saved a lot of time, and we would have saved a lot of money not having you go back and forth had this case only been litigated post-COVID.
Yes, that's true. And, it's fascinating because it was still going on during COVID, and there were depositions that then I took remotely and came to find that there were a lot of benefits to it, especially on certain types of depositions where you're dealing with spreadsheets and that kind of thing. And you really, it just would be very difficult to be bringing up the data and walking through someone through this electronic data and having them explain what different cells or columns mean. It was, I came to really appreciate the ability to take depositions remotely, not only because of it avoided me having to travel 12 hours to Alaska, but it also, there turned out to be actually ways in which it was much more beneficial and straightforward to use this kind of system in taking a deposition.
I couldn't agree with you more. I've taken depositions, I've defended depositions, I've done mediations, scores of mediations in COVID and post-COVID, all remotely. And I don't know that there's really any downside to speak of. I think by and large, there's huge upside to these things, and certainly to the extent there's a balance of negative and positive, the positive overwhelms doing these things remotely. I always say to clients, if you want me to be together, if you want to be together with me in a mediation, that's fine. I can come to you, you can come to me. But generally, we do really well in a remote context, and we keep our data. And last year, we see that 92% of all of our mediations were successful, and virtually all of them, maybe every single one, but certainly the vast majority, were done remotely. And that statistic, 92% success rate, is really no different from the success rate of years pre-COVID when we were doing it together. And in terms of depositions, I agree. I think sometimes it's just easier to have all of your material in front of you, and as long as you have someone on the ground, a good court reporter or some neutral there handing documents and making sure things are happening, I think you could have as an effective a deposition as you would if you were present.
Agreed.
Yeah.
Yeah, no, and it's a good point about mediations. I mean, I think that most mediations are actually more efficient, if not more effective, done remotely. I think that, I noticed that no longer is it necessary to have mediations that go past midnight. So much of the time, mediations now are done, at a reasonable hour. I even recently had a couple of mediations, both of which a deal was reached in principle by mid-afternoon, which is, incredibly efficient. The thing about mediations overall is, while it can take some time to get onto a mediator's calendar, they are extremely efficient when you get to them. Bringing about most of the time a resolution within a day or so of the mediation taking place, which, without that, the delays that can happen in direct negotiations can be, take longer significantly. So, it was getting back to the Alaska case. It was, a great experience, and we obtained multi-million-dollar settlement for a class of less than 80 people. It was a enormous success. My only minor regret, and it's not even a regret, but it would have been a fun one to actually take to trial. We were scheduled to go to trial later that year, but following a mediation, another effective mediation, we got a deal done, and it was the right result, certainly, for the case, for the plaintiffs, for the class. But sometimes you do think about, well, and what if we hadn't settled? How would that have worked out? It would have been great fun.
Tell me, you have served as chair and co-chair of the wage and hour practice for a long time in our firm. And well, first of all, wage and hour is a term that always bothers me because I don't think most people know, your average person doesn't think, I am being ripped off by my employer. I'm not getting paid overtime. I'm misclassified in some way, and I should be getting certain benefits and certain pay that I'm not getting. And therefore, I have a wage and hour claim. I don't think most people have that thought process. Yeah. They think maybe wage theft at most. But we call it wage and hour. We should probably rename it. But tell me, how did the wage and hour practice evolve in a way that you became so integrally and intimately connected to it in our firm?
So I guess I would first have to start off with even before I joined the firm and, say that my practice, the focus of my practice started to be a lot of wage and hour cases, variety of different wage and hour cases, some misclassification cases, some were off the clock cases. Some were tip violation cases representing restaurant workers. And so I handled a lot of those cases. And then when I joined the firm, I actually brought a few cases with me, a few wage and hour cases that I continued to work on. And I worked on those. I worked on a variety of different cases, including, as we talked about, the False Claims Act cases, but and discrimination cases. But I always was working on wage and hour cases, and because of my past experience, I was also kind of a resource for people when it came to wage and hour issues. And so as being this resource and being someone who was involved in, many of our wage and hour cases, the firm thought it made sense for Andrew Melzer and me to be jointly leading this wage and hour practice, which we have. And, it has continued and has, we've handled a variety of different cases and over the years. And it is what I enjoy a lot about the firm, like I noted before, is it allows me to lead a practice area like that while also working on a variety of other matters. So
in other areas. And that's one thing I really love about you, because when I think about cases that we have and cases that come in, I often assign it and route things to certain people. I often think about you, but it doesn't matter what the area is. Like, it could be wage and hour, it could be wrongful termination based on gender or based on race or based on age. It could be a class action. It could be a multi-party matter. It could be a key tam. It could be an ERISA case. It could be a criminal sexual violence case. It could be a case in any of our areas. But I always think of you as a really good option, because you really are not only a great team player, always willing to step into the breach and take on whatever is necessary to take on, but you're also good at all of these things. Do you think of yourself as a generalist when you practice law in that way? Or is there some, like when you're at a cocktail party and you're introduced to someone, they say, "What do you do?" How do you describe yourself?
Sure. I guess I do think of myself as a bit of a generalist, at least on the employment side. I mean, I describe myself as an employment lawyer, and I typically then explain that I represent employees when they've been discriminated against, wrongfully terminated, denied wages, retaliated against, so I hit on all of that because I do see myself as someone who handles all of that, and I take pride in the fact that I believe that I have been successful and hope to continue to be successful in all of those areas, and I appreciate that the firm has confidence in me.
Well, we do, and I hope you continue to do that for another 12 years or 24 or 36. It's a great pleasure being your partner. Thank you so much.
Thank you, David.